I'm multiple family, so I may be putting you on mute.
All right, we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Good morning to all of you. First, I want to begin by thanking you both for participating via Zoom. We know it's a challenge. It's a challenge for everybody in this particular time. I want you to know that we will be patient with any technological difficulties that you may have, and we expect you to be equally patient with any difficulties we may encounter during the course of the argument. Before I introduce the panel, I just want to say on behalf of all of us that we hope that your members of your family and friends are safe and well, and that you've been able to weather this challenge in the best possible way. It's not easy for anyone. Today, joining us is Justice James Milkey, Justice Kenneth Desmond. I want to remind you that the regular rules of appellate procedure apply to these arguments, which means that you each will have 15 minutes. I understand there is a cross appeal here. That no one will speak twice. You will speak only one time and address all the issues during that time. There is no rebuttal in any event in the appeals court. With that said, I think we're ready to start. I'm going to formally call the case. PAUL KUBIC and another versus David AUDETTE, 2019-0371. Mr. KUBIC has been designated the appellant in this case. So therefore, Attorney Shapiro, I apologize. The floor is yours.
Thank you. If it pleases the court, I'm Nicholas Shapiro. I'm the attorney for the plaintiff appellants, Vince and Paul KUBIC. I'm sure we'll discuss littoral boundaries and ownership of monumentation this morning. But before we get to that, if there's one thing that I'd like to stress to the panel is the real world human costs of an erroneous and incomplete judgment like the one that entered in this case by the land court. My clients have lived at the properties, which are themselves quite modest, that abut the right-of-way at issue in this case, their whole lives. They're in their 60s. They've spent a small fortune and 7 years trying to vindicate their home. And I think it can get sometimes lost in academic conversations about some of these title issues that these are people's homes. Of course, under present circumstances, the importance of home has become more of a paramount consideration than in normal situations. But
I think I can tell you that we understand all of the consequences of this case. Not only have you read through the transcript and understand what's been going on, but of course the photographs reveal quite a bit as well. So it's.
Can I ask you a question though, in terms of what you consider an incomplete judgment? As I'm sure you're aware, the judge has now fully retired.
yes.
So unless we were able to resolve every issue here as a matter of law, it would have to go back and it'd be before a new judge and new hearings. And how is that really any different in a material way from what the judge did in terms of saying you could bring a future case about the ownership of the relicted area?
Well, I think it's a great question, Your Honor, and I've had conversations with my clients about that. Typically in a case such as this, the remedy would be a vacate and remand for proceedings consistent with this court's decision. I think though most of the issues involved in this case, if not all, actually could be resolved on this trial record. There actually really wasn't a whole lot of factual dispute in this case. The disputes, I think, can geographically be categorized to track the thirds of this right-of-way. The upper third by Fairfield Street, the public way, it involves disputes that sort of emerged during the pendency of the lawsuit. As your honors are probably aware, the upper portion of the right-of-way has, from the beginning, has had the driveways serving both of my clients' properties running, flanking both sides with the right-of-way extending through the middle. And these were the driveways that were developed from the very beginning by the developer of the subdivision in the first place. These driveways predated my clients' ownerships of their properties and even their parents' ownership of these properties. And so in the upper third, there was some decision by the trial judge, but not a complete decision. In the middle section where the pavers are, where the passing and repassing goes on, there's actually not a whole lot of dispute, really. And then there's the bottom portion, which we refer to as the relicted area, over which there is quite a bit of dispute. And in fact, that was the impetus of the lawsuit in the first place. And the trial judge just rendered no decision at all as to that bottom area.
But focusing on the bottom area,
Sure.
Now, under your theory of the case, that's a right-of-way owned half by each of your clients. What is the scope of the easement? A question that no one focused on that much in terms of the ability to use that particular area. Is it pure access to the water, or would, for example, standing by the water, enjoying the view, would that be included? What is the scope?
Well, so my understanding of the scope of it is that it's a right-of-way. I think the granting language even said right-of-way to Lake Webster. The piece of property that the parties have been disputing is labeled a right-of-way. And this is a term of art under Massachusetts law. We've cited the Bucciolacci decision from this court for what a right-of-way is, which it's an easement of access for passage, ingress, egress, passing and repassing. And so that was one of the errors in the decision that the trial judge did make, was that the trial judge determined that an easement of passage included an unfettered right to park, which is partly why, in terms of the criminal proceedings right now, I sort of wanted to talk about the upper portion first, because we have this incongruity that the trial judge, in passing, said that both of my clients can continue to park where they've been parking, erroneously ruled that this easement, and ruled, because this is a legal question about the scope of the easement, included the right to park, but then didn't explain to anybody how this parking was to work. And so what ended up happening after the entry of the judgment, after 7 years, my clients thought they did the right thing. When parties can't resolve a dispute, you're supposed to go to court. Remedies aren't perfect, but they are supposed to be complete. Nobody has an entitlement to win, but they do have a right to have some order imposed on things. And it was actually a fight over putting a sign saying that people who are not authorized to park would be towed. And so physical altercation erupted based on that.
Okay, just
sure.
Counsel, with regard to the parking.
Sure.
If we were to conclude, and this is pure hypothetical, that the easement did not include a right to park other than to, unload a vehicle down by the dock, would that, as a practical matter, resolve the parking issues, and we wouldn't have to deal with all of the other claims related to the parking?
I believe so, Your Honor. I should just note one thing, though. The trial record is, this is an example, I think, of the trial judge being clearly erroneous, which is the trial record. Mr. Audette's testimony establishes that the boats don't get launched here. Boats get launched at Memorial Beach in town. Right. There's no ability to launch boats here. So this is not an easement to launch boats. This is passage here. Yeah.
I understand. Well, I'm not sure I completely agree with that, in the sense that, if someone has a right to use that path and drags down a kayak, presumably they could launch the kayak down there.
To answer your question, Your Honor, I understand the easement of passage to the Great Pond to be essentially an easement that allows the easement holder to effectuate his public trust rights in the pond. That's what I understand it to be. And that would include fishing, fouling, and navigating. So if you had a handheld boat, a kayak, absolutely, you could launch your boat in that way. I just meant motorboats, Your Honor. So I think if the panel were to rule that the easement doesn't encompass an unfettered right to park, that would resolve the parking issues up at the top. But it doesn't resolve the fact that having just reviewed the trial transcript again, the Martin claim as to Paul's parking area stood virtually uncontested at trial. There was no even assertion that if Paul parks only in his parking area, people won't be able to pass. And in fact, that was one of the reasons why the trial judge said there's been no extinguishment here, of course, eliding over the case law Lemieux, that if there's parking in, if there's an obstruction in one area, that area is no longer going to be subject to the easement.
Can I stop you? Why don't your clients have a conflict of interest on the parking, in that if they both were to park in their respective areas, they could in fact block the easement?
So I think this was one of the mistakes one of the analytical mistakes that was made at the trial court below. We're only seeking to reduce the easement as to Paul's parking area, not the driveway that gets you there. That has always been used as part of the right of way, and they're staggered parking areas. So geographically, they both can park, and this was clear in the trial record. And in fact, our expert PE testified was that if Paul parks in Paul's parking area and Vince parks in his driveway, that there's plenty of room there for people to pass and repass. And even on Vince's Martin and partial extinguishment claims, that was only partially opposed at trial. The last exhibit that was admitted into evidence was a markup of the Martin plan that showed the extension of a 16-foot right-of-way all the way up from the pavers. And so if we only applied Martin to the essentially what the defendant was asking for was not a complete, was essentially part of the Martin claim should fail according to the defendant, not the whole thing, because you can see where the line would be. So beyond that line, my client could park without affecting Mr. Audette's access at all. And so it really was not appropriate for the trial judge to render no decision on it. I mean, Martin is the law of this Commonwealth, and Martin stands for the proposition that serving estate owners can reduce the amount of their property subject to an easement.
By Martin, you really mean MPM builders, correct?
I don't think that characterization is fair either, because MPM was a relocation case. It wasn't until Martin that the SJC made it clear that this section of the restatement was adopted, including the portion of that provision that says that you can alter the dimensions of an easement as well. And so and that didn't get handed down until 2015. So this really wasn't a claim that could have even been brought in the prior litigation. And frankly, res judicata is not a matter of subject matter jurisdiction. All defendants except Mr. Audette were defaulted. Mr. Audette didn't file an operative answer. In the pretrial memo, he asserted a claim for essentially material interference based on Vince parking in his driveway. Most of Mr. Lane's questioning at trial was on, is there any impeding of access when Vince parks in his driveway? And there wasn't an assertion of res judicata in the brief as to that claim either. So there's really no felt ground for the trial judge to say these claims are barred, other than wanting to vindicate prior orders. But this is an affirmative defense. It was just not appropriate. I think I probably should move on to the boundary issue at the bottom, in that all necessary parties were either joined or filed an amicus. In the record here is a trial level amicus brief from the Commonwealth that disclaims ownership to any re-emerged land. What the Commonwealth was concerned about was that its ownership of the lake bed, remained sacrosanct. And it's been our primary position in this lawsuit that any conveyancing by the Robinsons, the original owners of this common estate, that purported to grant submerged land was ineffectual ab initio. And we would submit that either the normal rules of the littoral boundary moves with the water line should apply, or the special rule in Payne v. Woods that if it's a dam controlled pond and water levels have been manipulated by the dam so that the water line reaches a permanent new normal, which there was 60 years of testimony that the water line, it fluctuated seasonally, but to the naked eye, it really didn't change all that much.
Do you concede that it's a dam-controlled pond?
We don't concede it because we objected. There was no disclosure about any facts about the pond, about the dam, Your Honor, from the defendant. And so we objected strenuously throughout the whole thing. But under the case law in Massachusetts, it doesn't matter whether it's natural, it's man-made, or some combination of both. The only exceptions to this legal presumption is if there's an avulsion, some cataclysmic storm overnight that changes the boundary line, or if there's been governmental action to aid navigation. The Commonwealth has effectively disclaimed that in its brief. Or if the littoral owners did things themselves to cause the change in water line, and our clients did absolutely nothing to change the water line. And so this is just a thoroughgoing application of existing law on this point.
Now, counsel, the part of your claim was that the dock, in terms of its size and configuration, was itself overburdening the easement. The judge, for a bunch of obvious reasons, did not make any findings as to that. Even if we were to agree with you on the property issues, wouldn't that have to go back?
To be honest, I don't think that it's basically a legal question of title, and the facts only matter under these doctrines if they're facts that would overcome the legal presumption that the water line sets the boundary.
No, I'm not talking about ownership. I'm talking about if we were to agree with you that your clients established ownership of the fee in the relicted area, what are the ramifications for the dock, which has a Chapter 91 either permit or license? And as I said, part of your claim appears to be that the dock itself was overburdening the easement.
That is correct, Your Honor.
So
generally, that's a factual determination. You're right, Your Honor. So it very well.
So at a minimum, wouldn't that have to go back to a new judge?
The only thing, Your Honor, is that there were Google Earth images and a lot of testimony. This dock is bigger than anything that has ever been there or is in the vicinity, and it does effectively block the whole use of it. So I think going down to one float would even be a self-apparent remedy on this record. Before my time is completely up, I just wanted to turn the panel's attention quickly to a decision from this court that we had missed up to this point. That's from 2018, Small and Beach Association, Inc. v. Geneva, 94 Mass App Court 106. I just wanted to identify that to the panel because in that decision, both Payne v. Woods and inhabitants of Linfield, which was in the alternative theory that this is still physical monumentation, so there's a derelict fee squared issue here, even if we assume private ownership. And the Small decision reaffirms the continuing vitality of these decisions. In fact, inhabitants of Linfield was why a panel of this court said that there were indispensable parties, the owners of the Great Pond, their heirs needed to be joined to any aspect of the case on remand. And so I just wanted to point that authority to the attention of the panel so that the panel is aware that these are still, despite their old vintage, these are the cases on this type of issue.
Okay, counsel, just quickly, you're not contesting that Mr. Audette has an easement to use the right of way, correct?
Correct. And we're also not saying that the easement stops at 100 feet. It goes.
No, I understand that. But for Mr. Audette to own an easement, didn't the Robinsons or their heirs have to have held fee in 1966 when it was deeded out?
No, Your Honor, because there would have been implied reservations as to Vince's an implied reservation as to Vince's side, because this is a common scheme. The common scheme case law, whether you're talking about Regan v. Brissy or Graveline v. Leahy. And so they certainly would have reserved an easement for the benefit of the rest of the common estate under that theory. And then Mr. Paul Kubic's side, the case law is clear that whether you use language of exclusion or reservation doesn't so much matter. And so to specifically refute the argument made by brother counsel that what was the point of excluding an easement? Well, if you apply the derelict fee statute, well, there's a couple of reasons for the exclusion of the easement. One is to say that Paul's property does not have an express or pertinent easement over the northerly Vince half of the right of way. And it would have been to reserve an easement over the southerly half as well. And so that language would still isn't rendered surplusage by the application of the derelict fee statute. So the Robinsons would have, the remaining land of the Robinsons would have had an appurtenant easement over this right of way that would have descended through the severance of all of those lots at the time of the original severance of my client's property from the common estate.
Does the panel have any further questions, Justice Milkey? Justice Desmond? Thank you very much.
Thank you, Your Honor.
Okay, Counselor, Attorney Lane?
Your Honor, Henry Lane, representing Mr. Audette in this case, and my argument basically is going to focus just on the two issues that I think are important. The first is the application of the derelict fee statute. Obviously, our appeal argues that Judge Cutler made only one mistake in this case, and that was misinterpreting the derelict fee statute as applied to the southerly half of the right-of-way. Despite suggestions in some of the filings that the intent of the grantor didn't make a difference. In fact, the statute uses that very word to say that one has to essentially determine the intent of the grantor when they grant the parcel of land that is bounded by a monument, in this case, a right-of-way. And I don't think you can interpret it fairly any other way than to say that the Robinsons, when they granted the southerly part of the southerly lot, shall we say, they explicitly reserved or accepted the right-of-way. And it's hard to understand how somebody could somehow infer from that yes, Robinson intended to convey the underlying dirt, but expressly said that although we're granting Paul Kubic's ancestors the dirt, we are prohibiting from using the dirt. That just doesn't make sense. And understanding, of course, that this deed was done in 1957, and had this case come up in 1957, under the rules of construction in place at that time, it's very clear that the court's ruling would have been that the grant to the southerly lot did not include one half of the right-of-way, because it doesn't refer to the right-of-way. It's not bounded by the right-of-way. It's simply a course with distance. And therefore, under those prior decisions, as I say, had this case been brought in 1958, 1959, 1960, it would have determined that the Robinsons retained the fee in the right-of-way. Now, did that change in 1971? Well, perhaps it did. And the inference of the old rule of construction was hardened a little bit. But in fact, the legislature still left the intent of the grantor as paramount when it decided that we needed to determine the intent of the grantor if there was an exception or restriction. And in this case, there was. So the general rule, basically, the general rule of construction, or now the derelict fee statute construction, is modified, and the intent of the grantor once again becomes material. And again, as I indicated, it's hard to understand how you could just to suggest that the Robinsons intended to convey the dirt, but prevent Paul from using the dirt. The only thing that makes any sense.
Counsel, I'm understanding what your argument is. How does that matter for you, where it's the northern half of the right-of-way that people drive on, that the dock appears to run off of, and such? What's the import? Even if you're correct, I assume you're saying that your client owns the fee in the southern half of the relicted area. Of that, is that what you're arguing? Or?
Well, that's half of it. The other half, of course, it resolves the question of parking. If in fact Mr. Audette owns the dirt, then he can park on it, and his guests and friends and invitees can park on there as well. And it, as your Honor suggested, takes out the whole question of the relicted area, because obviously Mr. Audette also has title to that. So if the decision on the derelict fee statute comes out in favor of Mr. Audette, all those other questions disappear. And
well,
I think
can I stop you that? Do they? Because, for example, the area of the paving stones is plainly on the northern half of the right-of-way. Just to choose an example, even if you're correct about the ownership of the fee in the southern half, what allows Mr. Audette's guests to use that right of way even for access?
Well, he owns it.
No, he doesn't own the northern half.
He owns the southern half. You'd have to move the driveway to the southern half, but that's a relatively minor issue. But the key issue, he'd be allowed, and he and his guests would be allowed to park on it. And that's, as I say, as a practical matter, that's the important issue.
Why does the parking matter when, based on the trial record, it appears there's plenty of parking on the street, and Mr. Audette himself owns property a couple hundred yards down the road?
Well, first of all, as I guess the evidence was, it's more convenient since it's a fairly steep embankment going down toward the lake, that having to haul your cooler and your beach toys and whatever is a bit of a hike. So you have to hike down there and you have to hike it back up. It's much easier simply to park on the area and reduce the amount of travel you have to do on foot.
But most of the parking was done on the upper portion.
That's correct, but still, it's less walking than walking from his house, which is several hundred yards down the road, or parking in front of the Kubic's house and interfering with their easy access along the road. It's hard for me to understand why the Kubics would be interested in requiring the guests to park in front of their homes instead of on their side lot. But I guess that's their business. Our argument is that we'd like to have a convenient, safe, off-road parking. We think we're entitled to it, and we want to make the argument that under the derelict fee statute, we own the dirt as the successor to the Robinsons, and the exclusion and the restriction that he was not to have a right-of-way in that strip makes it very clear that the Robinsons did not intend to convey the dirt under that half of the right-of-way.
Okay.
And as you indicated earlier, Your Honor, it takes care of the related land area, because if Kubic doesn't own the dirt under his half of the right-of-way, the idea that there's a longitudinal aspect to the derelict fee statute also disappears. And it's very clear that under our theory of the case, that Mr. Audette owns the relicted area without restriction, and he can park on it or do anything else he wants to do on it, because subject to the right of anybody else that might have a right-of-way. But under MCM, of course, he could still use the majority of that land.
Counsel, say hypothetically we were to disagree with your theory about the interpretation of the derelict fee statute. What flows from that in terms of the ownership of the relicted area? Is there any theory other than that your client can claim a fee in the relicted area?
Yes.
And what is the?
Under our reading, if the derelict fee statute applies, it can only apply to the right-of-way, and not to
go ahead.
The right-of-way shown on the plan. It cannot extend beyond that right-of-way. I think where the plaintiffs make their mistake is conflating the end of the right-of-way with the edge of the water. Their argument is that the right-of-way and their rights under the derelict fee statute are controlled by the edge of the water. But in fact, the monument that's established by the derelict fee statute is not the edge of the water. It's an extension of their westerly boundary of the described parcel. And that extends, it happens to coincidentally, presumably in 1957, have been a high water mark, although their argument really belies that, because they're arguing that the water line had moved by 1957. But I don't think you can fairly conflate the boundary as an extension of the westerly line of their parcel with the monument of the edge of the lake. So, the cases seem to be pretty clear that the derelict fee statute works only latitudinally along the property line, not longitudinally. You don't get the land next to your property and then extend it, presumably who knows how long. And that ties into, part two of my argument, which is that, the plaintiff's reading of Payne versus Woods is erroneous. Payne versus Woods reestablishes the traditional view that when you convey by a watercourse, you convey to the low water mark of the historic water course, not the one established by an artificial impoundment. That's the quote in the plaintiff's brief quotes the older decision, which is overruled by Payne versus Woods. So that argument is entirely off the mark. Payne versus Woods says that it's the historic limit of the Great Pond that is the limit of the deed of the land conveyed by a deed that goes by the water course. It does not change over time because there's a dam. And this SJC reaffirmed that in his 2016 opinion, where it basically says, look, that's not the case. We haven't made that decision. They obviously read Payne versus Woods correctly.
Why aren't you reading too much into what the advisory opinion says? A, it's an advisory opinion. B, they said, okay, this question is too open-ended and too untied to the facts. We're just not going to deal with it in this context. Wait till the facts come up.
Well, but they acknowledge the fact that they have never made a decision that says that the artificial impoundment of water changes the title to the land under the water. And that proposition raises a whole host of issues. And you know, just to back up on that, Judge Cutler, I think, made the appropriate decision, even with respect to that relicted area. The suggestion that, if you look at the facts, in 1948, the water line presumably was where the recorded plan shows it was. And we know that by 1964, when Mr. Kubic attains consciousness, it has moved somewhere between 40 and 50 feet westerly. Now, is it possible that over that 17-year period, as a matter of gradual accretion, or the land moved approximately 3 feet per year for 17 straight years, and suddenly in 1964, that 17-year period of gradual accretion of approximately 3 feet per year ended? That's a wholly unlikely inference. What the real inference is that, look, in 1948, somebody built a subdivision. Before 1948, it was just open land. 1948, they started selling land. They granted easements and rights of way. And lo and behold, rather than the water line being at the toe of a steep slope, it moves out 40 and in the center 50 feet in that 17-year period. That suggests to me that is not accretion. That is avulsion. Somebody went down there and decided we want better access to the water, and we extended the toe from the toe of the slope to the water.
Not to get too specific, but isn't your claim that the water level was lowered by letting water out at the dam, which is frankly neither reliction nor avulsion, but just lowering of the water level by the dam?
And that certainly supports our argument. If it was simply the lowering of the water in the dam, that doesn't change the water line. That doesn't change the title. Then the title stays in Robinson and ultimately in AUDETTE as the successor to the Robinson rights. So either way, AUDETTE owns the relicted area and he can use it. So
based on the purchase of the reserve deed for $250.
Well, I think it was 500 because it was 2 halves at $250 each. But yeah, I mean, obviously, you know, obviously Mr. AUDETTE, you know, not having actual waterfront property, did the best he could and took advantage of the circumstances and said, hey, you know, I have a right to the water. And I have a dock license. I'm going to make the best of it. And if he can strengthen his title to the land by getting a deed from the heirs of the Robinsons, he did it. And you know, so he, you know, he took advantage of the circumstances and you know, good for him. Now he also has access to the lake. And despite,
well, how does he have access to the lake unless he owns the fee?
Well,
I mean, does the right of way provide access to the lake, in which case it would extend as the water level is lowered?
Well, he gets it either way. Somebody has to own the relicted area. So if it belongs to the Commonwealth, then it's public land and he can use it like like anybody else can. If it belongs to the Kubics, it's subject to a right-of-way, so he still has access to the lake. And if he owns it as he claims, then it's his land. No matter what happens, he doesn't lose access to the lake. The dock is in the lake, and under the theories of both the Attorney General and the Kubics, the land under the lake belongs to the Commonwealth. He has a license to have his dock in the Commonwealth land, so the Kubics can't, despite 10 years of effort and almost 2,000 pages of record in this case, which is just over litigation to an extreme, the Kubics are not going to be able to get Mr. AUDETTE off the lake.
Okay, I think you acknowledged, tell me if I'm wrong, that whoever holds an easement in the right of way holds an easement down to the current lake. Is that accurate?
No. I'm certainly willing to take that position, but that's not my primary position. But if the Kubics succeed, then yes. If the
How
Kubics
is
own
it?
that land, if
But
the
how
Kubics
is it? How is it that he's got an easement in that area if the Kubics own it, but other parties don't have that easement if he owns it?
because the Kubics can only own it by virtue of the derelict fee statute. And the derelict fee statute only gives the Kubics title if it's a right of way. If it's not a right of way, it's not a monument, and it's not subject to the derelict fee statute. The Kubics can't have it both ways. They only get title if it's a right of way because it's only a monument, or a linear monument if it's a right of way. So Kubics have to decide. If they want to claim title, it's subject to a right of way. They can't claim title if it's not a right of way. So we don't think it's frankly a right of way. We think the right of way ends where the plan says it ends, and then the relicted area is within our title. But if we lose that argument, we can only lose it if the Kubics have gotten title to that strip by the derelict fee statute, and the derelict fee statute can only give them title if it's in fact a right of way. So either way, we retain access to the lake and to our licensed stock, within the lake.
All right, your time is up. I'm going to check with the panel to see whether or not there are any more questions. Justice Milkey, no. Justice Desmond, I see no.
One question, how long is the license for the dock, and what period of time?
I don't know offhand, but I know it is renewable.
15 years.
I
We're halfway done.
can do it all again.
Thank you both very much. We appreciate your arguments, and we'll take the case under advisement.
All right, we are live streaming.
Good morning. Good morning to you both. Thank you for participating in oral arguments today via Zoom. We know it's a challenge for you as well as for us, and so we very much appreciate it. On behalf of the panel, I can assure you that if we have technological difficulties, we will remain patient, and we hope that you remain patient with us as well. Before I introduce the panel and go over remind you about the rules of appellate procedure, I just, on behalf of the panel, want to say that we hope that you're both healthy and safe, and that your family and friends are as well. It's a difficult time, and we we know that, and we feel strongly that it's important to keep everybody at a safe distance and conduct our arguments in this way to that end. With me today is Justice James Milkey, Justice Kenneth Desmond. My name is Ariane Vuono. The regular rules of appellate procedure that apply to oral arguments in the courtroom apply here. Each side has 15 minutes. There is a cross appeal in this case. My understanding is that the officers, which I'll call them as a group, the officers are the designated appellants. Attorney Shapiro, you'll be arguing first. There is no rebuttal. You won't be arguing again afterwards, so you should address all of your arguments during your 15 minutes portion. All that said, we're ready to go, okay?
Thank you, Your Honor.
One moment, and there's the clock. Go ahead, please. Thank you.
Thank you, Your Honor. My name is Alan Shapiro, and may it please the court, I represent the 6 police officers in this case. And I want to thank Justice Vuono for her gracious explanation, and I appreciate the court and the court personnel's efforts in order to advance these cases so that they can be heard. And my clients had been waiting a long time to get to this point. These were 6 police officers who were fired by the police department between 2002 and 2004, solely because a hair testing company said that their hair samples indicated they had used cocaine.
I can help you out in that we're familiar with the case. We're familiar with a prior case in this court and the history of the case, and we know it's been a number of decades in which this case has been going on.
Yes, thank you, Your Honor. But
Well, I guess under 2 decades, over a decade is what I want to say.
right, but the amount of time it has taken does figure into this case, Your Honor, because interest is certainly an issue here. So suffice it to say that the original decision of the Civil Service Commission in 2013 was affirmed and the remedy expanded by Justice Fabricant in 2014. This court upheld that decision in 2016 when further appellate review was denied. And that's when we started to have problems with the police department regarding the back pay. So the order of civil service in the courts was that these officers be reinstated with full back pay. The police department, after the final ruling by the SJC in 2016, finally offered reinstatement in September of 2017. 3 of the officers were young enough to go back on the force and re-entered the police academy in September of 2017. The other 3 officers had enough years, given the amount of time since they had left the department, and should have received back pay and creditable service to be able to retire. And they made that request of the police department. But in order to do that, there had to be back pay from which contributions could be paid into the retirement system. The police department only gave back pay to 1 of those officers, Officer Jones, with a back pay that was paid in February of 2018 to Jones, partial back pay, and partial back pay to the 3 officers who had already gone back on the force. They made no back payments to 2 of the officers who were seeking to retire and still seek to retire. That would be Officers McGowan and Beckers. So the case—
That prompted your motion for contempt, correct?
That's correct. That's correct. So we filed a petition for contempt, and it was essentially handled as an action for damages. And I want to say that even though, as you pointed out, we are both appellants and cross appellees, we agree with the decision that Judge Tochka made. We feel that Judge Tochka followed settled Massachusetts law in the areas of mitigation, in the issue of interest, and in the way he treated the back pay. So
well, I thought that you were contesting his decision not to award post-judgment interest.
Well, yes, but I cannot say that there are precedents where we could point to where civil service decisions have led to post-judgment interest. There is a logical argument that one could make based on precedents under Chapter 151B, the anti-discrimination statute, and actually under Chapter 150E, the collective bargaining law, where the courts have found that post-judgment interest applied by necessary implication.
So you're certainly not conceding that at this point, are you?
I'm not conceding that it's impossible for the court to reach that conclusion. I am saying, however, that Judge Tochka followed current law in that there are several civil service cases where based on chapter 231, section 6C, the courts have found that the civil service law forms a contractual relationship,
Mhm.
and therefore that prejudgment interest applies. We agree, Judge Tochka got that correctly. On post-judgment interest, that would be something that has not yet happened judicially. So I'm not conceding that it would be wrong to do that, but I am conceding that Judge Tochka followed current law.
Okay.
And I think that the mitigation issue that Judge Tochka handled, which is a very large portion of this, because the police department took the position that unless an officer had a W-2 for a particular period of time, that officer therefore failed to mitigate and would receive no back pay for that period. And hence, we have 2 officers who were fired 15, 18 years ago and haven't received a penny based on.
I think that their point, I'm sorry. I understood that their point was not that it was necessary to have a W-2, but that in the case of some of the officers, 2 in particular, there was no effort on their, as far as the department's concerned, to actually obtain employment. There was actually a choice made to not be employed for specific personal reasons.
Yeah, actually, Your Honor, for Officer McGowan, it is true that she stayed home and cared for her mother and lived with her mother and did not seek alternate employment. That's true. And Officer Beckers, however, there is nothing in the record to indicate he didn't look for other jobs.
Mhm.
He didn't find other work, and he ended up moving to Honduras and opening a bed and breakfast where he hasn't shown a profit, but he has been able to live there.
Mhm.
But that stands the mitigation law on its head. If we go back to the McKenna case in 1964, where the SJC found that even though McKenna, the employee in that situation, had done nothing, if you look at, I think it's footnote 2 in that case, there's a colloquy from the case where he's asked, what did you do to look for a job? He said, I didn't do anything. I stayed home. And yet, because the employer couldn't show that he could have gained comparable employment with reasonable efforts, that therefore the burden is on the employer to show that the officer or the employee failed to mitigate.
Does comparable employment mean comparable by way of tasks, comparable by way of pay, or both?
I think the cases say that comparability means it isn't necessarily just money, although that's certainly a big part of it. And there's certainly no showing by the police department that officers who had been fired for using cocaine at the time could go and apply for a job that was going to give them comparable pay. It also can include status. It can include how one's life is viewed with the degree of respect
Mhm.
that police officers have. So
would you
it
say
isn't
that
necessarily.
Would you say that the TSA position, is that comparable? I understand that the officers' salary is about $102,000. The TSA job offered about $62,000 or $60,000, I think. Arguably, a TSA officer is one who's held in some repute because of their job and their law enforcement flavor or tendency or approach to that job. So would that be a comparable job?
I don't think so, Your Honor. I mean, first of all, there is a $40,000 gap in pay. So I think that's a huge problem. And secondly, there's no evidence. Yes, there's evidence that an officer who tested, not at one of the ones in this case, but one who had tested positive and resigned, was not fired, ended up with a job with TSA at some point. We don't know when he got that job. We don't know whether there was any availability for those jobs for these officers. But I think it would be, we don't really know a lot about the job, but it seems to me that a Boston police officer has a status in the community, has an ability for promotional opportunities, and of course the income that I think would be considered to outweigh that of a TSA agent. But again, there's no showing that these officers had the opportunity to even apply for that job, that it was out there. If you look
You
at
say that, of course, was the burden of the department to show.
yes, and if you look at the cases where employers have met that burden, they have shown that there were advertisements, like for teachers. There were teachers who were terminated for back in the dark ages for being pregnant. And the issue on mitigation was there were advertisements for similar teaching positions, and that were local, that were in the same area. That in the
You would
same area where
expect
they
something
taught.
like advertisement by the Cambridge Police Department or some other department close by. That would be, in your view, something that would be.
If the Cambridge Police Department were advertising for police officers at the time these officers had, during the term, after they'd been terminated, and there was evidence that a terminated Boston police officer could go to an interview in Cambridge and be asked, why did you leave the Boston Police Department? And they truthfully said, because they fired me because they said I used cocaine, and they could then get a job as a Cambridge police officer, yes, that would meet the employer's burden.
I
But
see.
there's absolutely no showing of that.
What about the sheriff's office?
Well, that was, first of all, we have no knowledge of the availability of those positions. That was the example that was used was a police cadet, not a police officer, whose hair had tested positive, who resigned. She was not terminated. She never became a police officer. The pay of I think they mentioned a pay of something like $61,000. In the same economics report, The Economist said in 2006 that the average Boston police officer made over $100,000 because of the overtime and pay details, et cetera. So there's no showing of the contemporaneous availability of that job, that these officers could have gotten those jobs. And I think also that in terms of, is that a comparable position to go from a Boston police officer to a corrections officer in a municipal facility? That wasn't really something the judge assessed because there wasn't even a showing of availability. So I don't think that the court even needs to reach that point.
Your time is almost up. You haven't touched upon all of the issues that have been briefed in this case, which is fine because we can refer to the briefs. But in your last few seconds, is there anything else that you wanted to bring to our attention?
Well, only that I just think these officers have been waiting an awful long time, and that we appreciate that the court is hearing this and can put final closure on this case. Thank you very much.
Do anybody else have some questions? Yes.
Just one quick question on the tax burden argument. Your brief seems to treat this as a matter of law, as if the judge had said, I have zero authority to adjust for this. That isn't in fact what the judge said, is it?
I think the judge said there's no precedent for it in Massachusetts. There are federal precedents for it, but I would point out that the interest award using the statutory rate of interest, that does address the inequities, at least some of the inequities of these officers receiving a lump sum payment and the tax consequences, as opposed to if they had been paid that amount of money annually. So I do think if you look at it in conjunction with the prejudgment interest, and certainly if the court were to accept post-judgment interest, that if you looked at it as a whole, I think that would still be an equitable result without dealing with the tax issue.
Thank you very much.
Thank you.
Counselor?
Good morning, Your Honors, and I echo my brother's sentiments. Thank you for all your efforts in making this Zoom appeals court argument available to the parties and to move this case along. We also wish that everybody is healthy and well. Now, moving towards my my brother's point regarding tax liabilities, the trial court addressed that issue correctly, and the department would request that this appeals court uphold that ruling, because as my brother acknowledged, there is simply no Massachusetts precedent that allows the Superior Court to award additional income or additional damages to account for some speculative tax liabilities. A couple of subsidiary points on that matter. One, there is no evidence in terms of what are the tax liabilities these officers allegedly incurred. There's simply nothing in the record to show whether they in fact suffered a greater tax burden than had they been employed by the department. It's just pure speculation. The record hasn't been developed by the officers on that point. So with the same reasoning that we look at the overtime and detail pay, the principles that apply and why those damages should not be awarded in a civil service case because of the speculative nature of those awards. As we learned from the White decision and the Framingham decision, the tax liabilities should not be awarded in this case. I'm sorry, Your Honor.
Can we move to that issue for a moment more specifically? The argument that you make that the officers are not entitled to any overtime pay or paid or compensation for lost paid details and things of that nature because the issue is speculative. And so we have Judge Cass's case in White and other cases that state that. But are things slightly different now when you think about how the mode of calculation and the availability of being able to look at what an officer would have earned with respect to those other opportunities over a 10-year, 12-year, 13-year period? What do you have to say about that? In White, we're talking about, I think it was a two-year period and was unclear, and the sheriff case was even less than a week. Here,
I apologize. I believe it was an 8-year period in White, and even in that instance, the court made a determination that a government employer is not required to presume based on averages what the officers would have earned in terms of detail pay or in overtime pay. And I think that recognizes an underlying principle here with respect to government employers. What we are dealing with is taxpayer monies, but we're also dealing with a civil service statute, which is very precise in what should be awarded. And in White, the court made a very clear distinction that only what should be awarded is whether the is only the base salary, because the court took into consideration what we have here, and nothing has changed since White. We don't know if the officers would have taken advantage of the overtime and detail pay. We don't know what there's.
Isn't that inherently knowable, to borrow a phrase from other cases? In other words, over a significant period of time, we can certainly ascertain that overtime would have been made available and the pay details would have been made available. You're correct. Who knows, on any given day or week or month, an officer would have accepted that, right? But you can average it out. Here that the officers did suggest formula that could have been further tweaked, but there is some way of knowing that. Would you agree?
I would agree that there are some formulas that the courts in other jurisdictions have utilized, but I believe that in this case, those formulas, even with application of those formulas, we don't have any such application here. There's no evidence as to a utilization of those formulas, what those amounts would have been. There's nothing in the record. And I think the reasoning from White applies here, which is we are dealing with, one, government employers, and two, we're dealing with hypothetical amounts over an extended period of time. Who's to say what particular amount would have been awarded to one officer versus another officer? And I think when you look at the civil service statute on a whole, I think there's a recognition that the damages have to be proved in a finite and definite manner. The hypothetical nature of those damages are not an acceptable principle for damages analysis. As the courts have recognized, even in Massachusetts, back pay award is not an automatic award. It's the underlying principle is one of equity. And that brings me to my next point on mitigation.
Well, isn't there some speculation with respect to the argument for mitigation, which is these jobs are out there, but aren't we speculating that they would have applied for them, that they would have been given those jobs in the same way that we're speculating that they may have performed overtime while employed with the Boston Police Department?
I think what the Massachusetts courts have said in terms of mitigation is what has the employer shown that are available, comparable employment opportunities, and what would the officers have reasonably likely obtained? Did they make a reasonable effort? I would disagree that it's speculation, because what the Massachusetts courts are saying is that what is the evidence to support the likelihood that those officers would have obtained comparable employment. And what we have here that distinguishes this case from a myriad of other cases that comprise the case law on mitigation is that we have actual employees who were similarly situated to the officers in this case. They had failed a hair drug test. They had all tested positive for cocaine according to the hair test results. And then they subsequently, following their departure from the department, they obtained successful positions.
Does it make a difference that they resigned and didn't get terminated?
I don't believe that there's a difference because they resigned, because there's still, I think it's reasonable to infer that in any type of application, there has to be some inquiry, particularly in the TSA position where there's urinalysis tests or other drug testing, whether an officer or an applicant tested positive on a prior drug test. And in here, I think the record is clear that both Carrie Hogan, who successfully obtained the Middlesex County Sheriff's Officer position, she underwent drug testing, as well as the TSA position. Mr. Wade also underwent drug testing. So I think the record is clear that despite a resignation or a termination, there still needs to be in the record evidence of a positive hair drug test in future applications. And with respect to Downing, Downing was terminated. He didn't resign. He was terminated. He successfully obtained positions of federal security guard responsibilities that were comparable in compensation and in responsibilities as a police officer position. And I would like to correct a couple of points my brother has made, particularly on these points. One, Mr. Shapiro has stated that the TSA position, we don't know when Mr. Wade obtained that position. That's simply not the case. We do know from the record that he obtained the position in 2006. And he was earning at that point in time $54,000 per year. He then increases his salary, and in 2008, we know that he starts earning $73,000. And I would point the court to the record of the supplemental joint appendix that the officer submitted on page 31 of that appendix, we know that evidence is stated. So I think there are some misconceptions about what exactly the department proved in this case and what the evidence establishes. The mitigation burden was satisfied by the department. What we need to do is show an available comparable position. That's number one. Number two, we need to show that it was unreasonably, there was an unreasonable effort on the officers to obtain a comparable employment position. Number three, they were likely to get the jobs. On all three aspects, the court erroneously determined that the department did not satisfy those burdens. I think what the trial court did is apply a more exacting, stringent standard with respect to comparability than the case law requires. If we look at McKenna and Ryan, for example, Massachusetts cases that talk about mitigation and what's required, what they talk about is similar work or similar responsibilities that is required for mitigation purposes. The Ryan decision in particular makes a particular point of saying where the employer had showed that the employee had failed to apply for other teaching positions. In that case, there were teachers who had been terminated due to their pregnancy. And in that decision, what the court said is tenured positions and non-tenured positions are equivalent for purposes of mitigation. So it's distinct as the difference between tenured and non-tenured positions. I think that illustrates what is the level of comparability that is required here. And to require a virtually identical comparison, I think stands the comparability framework on its head. And
Well, what about looking at something more direct? For example, a TSA officer does not carry a firearm, correct?
I don't know the answer to that, Your Honor. My understanding, I don't know the definitive answer to that, but I believe that they do carry a firearm. The Middlesex County Sheriff's Office, they carry a firearm. Carrie Hogan states
would that be a factor to consider?
I think it's one, but I don't think it's a bright line test. I think you have to look at the positions as a whole. Comparatively speaking, what are the responsibilities and the compensation and the benefits that are offered by those positions? And do they meet the comparability? This is not the sheriff for Suffolk County case. In that case, we had a corrections officer that was terminated, appealed, and the SJC determined that the sheriff's office did not satisfy the mitigation burden because the positions that were offered by the employer were bartender, comforter, and bouncer. That is not the case we have here. We have three positions that were not just available, but were actually obtained by officers similarly situated as the appellants in this case. The TSA position, the federal security guard position, and the sheriff's county position. We have if you have a side-by-side comparison of the responsibilities and the compensation and the benefits that are offered, particularly highlighted by Dr. Erath in the expert report submitted by the department before the trial court, and undisputed and uncountered by the appellants. He looked at those positions and he looked at the benefits, in particular, for example, the the TSA positions that were offered and obtained by Mr. Wade offered a savings and pension plan that was similar to the department's. The similarity between those those benefits and the responsibilities are similar to a Boston Police Department position. I do not think that there was a requirement that there be virtually identical benefits and compensation. It needs to be comparable, and that's what the evidence showed in this case. And I would also point out that for purposes of this appeal, my brother counsel makes the point in his brief that the standard of review is clearly erroneous. That is not the case. This was not a bench trial. This was not a case where witnesses testified and the credibility determination was made. This is a case where the evidence was submitted on the papers.
You say the review is de novo.
The review is de novo. That's correct, Your Honor. So this court is in the same position as the trial court to make a determination. And if you look at the evidence here, I think it satisfies.
But that said, I'm sorry to interrupt you, but that said, wasn't the Superior Court judge entitled, if he so chose, to disregard the report by your expert?
Yes, that's correct, Your Honor.
And you're saying we're in the exact same position, we can also disregard it if hypothetically?
I think you're hypothetically entitled to disregard that evidence, but I think that it would be erroneous for this court to disregard evidence that is relevant and material to determining whether the department satisfied its burden on mitigation.
Did you want to say anything about the prejudgment interest before in your last few seconds of your argument?
Thank you, Your Honor. I think that my brother counsels recognizes that are you talking about prejudgment interest or the post-judgment?
Prejudgment.
So I think that
you won on the post-judgment, at least below. So you are opposing the award of prejudgment interest.
So on prejudgment interest, I think the trial court erroneously determined that the action that the officers have brought derived from a contract. That's not correct. What the officer's action is based on the civil service statute. And if you look at the Broadhurst decision, which involved the unemployment statute, the court in that case determined that it was not a contractual relationship. The language in terms of determining whether there is a waiver of sovereign immunity based on the Chapter 231, Section 6C, is whether the legal consequences of the action derive from a contractual relationship. That is not the case here. The legal consequences derive from the civil service statute. It's purely and entirely statutory. So there is no waiver of sovereign immunity under Chapter 231, Section 6C. What we have here is a purely statutory action. The contract action was available to the appellants if they sought to grieve their termination under the collective bargaining agreement, but they didn't choose that avenue. Instead, they invoked the civil service statute, and because they invoked the civil service statute, the legal consequences that attach are derived from that statute. So that statute 231, Section 6.
I see your point. See your point, and your time has expired. Let me check with the panel to see if there's any additional questions, any follow-up questions. All right, seeing none, I thank you both for your argument very much. Take care of yourselves, stay healthy, and we'll get an answer to you as soon as we possibly can, okay?
Thank you.
Thank you.
All right, we are live streaming.
Good morning, Attorney Beal.
Good morning, Your Honor.
I want to thank you for participating in the argument today via Zoom. It's just some technological advances are well received by all of us, but they also bring upon occasion some difficulties. So if we have any, we ask you to be patient with us, and of course, we will be patient with you at the same time. Before I introduce the panel, I'd like to say on behalf of the three of us that we hope that you're well, that your family members are well, that everybody is healthy. Next, I'm going to just remind you that the regular rules of appellate procedure apply. It's only you today. You have a full 15 minutes to make your argument. You can be assured that we read the record carefully, and so you might not need to use your full 15 minutes, but they are yours should you use them. And with that said, I think we can go into the argument. The panel today consists of my colleague, Justice James Milkey, Justice Kenneth Desmond. My name is Vuono. So please start.
Thank you very much, Your Honor. May it please the court, Eric Beal on behalf of the respondent appellant. The lower court's order of civil commitment under Section 35 should be vacated, as I argued in my briefs, for two distinct reasons. First is that the order was issued without due process. And as I stated in my supplemental brief that was filed after the SJC decision in matter of a minor, in that case, the SJC held that in Section 35 commitment cases, the trial court is required to state its subsidiary findings of fact on the record, either orally or in writing, to give a basis for the court's decision in finding a commitment is appropriate under Section 35. Secondly, in the matter of a minor court held that the trial court must also state on the record why it found any hearsay evidence that was offered was substantially reliable. And finally, in recognition of the substantial liberty interests involved, fundamental liberty interests in civil commitment matters, the matter of a minor court held that as a matter of substantive due process, that a trial court, before it can issue a Section 35 commitment, must find by clear and convincing evidence that there were no less restrictive alternatives. I argue that the decision matter of a minor should be given retroactive effect to the present matter. This is a live controversy that has not been finally adjudicated. And under the SJC decision, McCormick v. Boston Edison Company, that's 423 Mass 652, that's a 1996 decision. In that case, the court said that when a decision involves a matter of constitutional right, considerations of constitutional principle, with rare exceptions, require retroactive application. And the court continued, a constitutional decision is not a legislative act, but a determination of rights enacted by the Constitution, so that all persons with live claims are entitled to have those claims judged according to what we conclude the Constitution demands. Additionally, in this court, the appeals court, in adoption of Gabe, which is 84 Mass App Court 286, that's from 2013, this court decided that retroactive application of a constitutional right to appointed counsel in a care and protection matter was appropriate, and it cited McCormick for the principle that due process rights and constitutional rights should, with rare exceptions, and none of those exceptions are present here, Your Honor, should apply retroactively.
Okay.
And so yes, Your Honor.
Counsel, if we agree with you on that point and were to vacate the order for lack of findings alone, would that do it? Since the case, as the SJC has made clear, it isn't moot looking backwards, but it certainly would appear to be moot looking forward. Would we have to reach any of the more substantive issues you raise in terms of insufficiency of the evidence and so forth?
Your Honor, my position is that should the court vacate the decision based on matter of a minor and the due process considerations, it would need not reach the insufficiency of the evidence issue. In addition, I wanted to clarify, if I could, the standard of review that I'm asking that this court to apply. If it does reach the sufficiency of the evidence issues, under Section 35, the petitioner must prove that there is a likelihood of serious harm due to a substance abuse or alcohol abuse disorder. And there are, as the court is familiar, there are 3 prongs under Section 35 for a likelihood of serious harm. And in this case, the trial court proceeded on what's referred to as prong 3, which is a very substantial risk of physical impairment or injury. And there were essentially 3 aspects of the evidence. But in matter of GP, the court held that a clear and convincing evidence applies in Section 35 commitment hearings. In GP, and also matter of a minor, the courts held that determination, determination of if there is a likelihood of serious harm, that is a legal determination that is reviewed de novo. And in a challenge to the sufficiency of the evidence, no deference is given to the trial court's decision on that determination. And that's the standard of review I asked this court to apply, should it be required to reach the insufficiency of the evidence argument.
Counsel, now I understand, you would not, that in your view, there is certainly insufficient evidence of an overdose risk here. Putting that aside for the moment, why is overdose, in your view, treated as a prong 3 issue and not a prong 1 issue?
Under prong one, those cases involve situations in which there's an allegation that the respondent is at risk to themselves via a suicide risk, and not a risk in which the allegation is that they're unable to provide for themselves in the community. In the case at bar, there was no allegation made that there was that type of risk under prong one or prong two.
But why is prong one, in your view, restricted to suicide as opposed to death by other means?
Your Honor, because there's the requirement that there be overt evidence of acts under GP that would satisfy that statutory definition. And in this case, the matter proceeded under prong three, both at trial and through a review at the appellate division, also relied on prong three. There was no allegation that there was a prong one or prong two type of harm in this case. And as to the sufficiency of the evidence, certainly in GP, the court stated that if there is an allegation of prong three harm, that harm must be, the evidence of overdose rather must be strong and specific evidence that the risk of overdosing is indeed imminent, and that the degree of probability that they will do so is high. As the court in GP also recognized, any respondent who has a substance abuse disorder diagnosis is at a higher likelihood of overdose risk. So the question really becomes, what evidence is sufficient for a court to find a likelihood of serious harm based on overdose? In the cases, as I said in my brief, the cases in which that overdose risk has been found are cases in which there was a prior overdose. And for example, in matter of the respondent had suffered an overdose, had required administration of Narcan, and that had happened in a reasonably close time to the hearing. In other matters, there was evidence of recent overdose. In the present matter, there is no evidence not only of what specific substances were alleged to be used, their quantity or their frequency of use. And there was also, Your Honor, no evidence that the respondent ever had overdosed, required Narcan, had been rendered unconscious by drugs, had suffered any ill health effects, and even with apparently in the evidence showing positive drug tests up to 2 months before the commitment took place, there was simply no evidence that she ever actually suffered any harm as a result of any of the substances that she may have been using. So I submit, in light of the lack of evidence of what the drugs were, or how much or how frequently they may have been being used, and that there was no evidence that she ever suffered any harm from it, that there was not sufficient evidence under GP to find a very substantial likelihood of harm. And in addition, Your Honor, the harm must be found to be imminent. And in matter of GP, the court explained that imminent means in days or weeks and not months. And I think if you look at the history of this case,
May I ask?
Yes, Your Honor.
Imminency may of course be an issue, but wasn't there some evidence of physical harm? Wasn't there observations made of your client's demeanor, skin tone, lost weight, bruising, things of that nature?
There was evidence, Your Honor, to that effect, but the statute speaks in terms of physical impairment or injury. And in the cases where the evidence has been found sufficient, again, there are cases in which the respondents were unconscious from drugs, were wandering in the street in traffic, or were falling down and had to be picked up off the floor. And there was no evidence of that nature in this case.
Well, wasn't there evidence that she left the facility and had been missing for 2 days? And that coupled with the perceived injuries she suffered from people coming in and out of her house, engaging in drug activity, isn't that the physical harm that they were talking about?
There was evidence related to that. I challenge, Your Honor, the quality of that evidence because it's based under looking at the patent factors, reliability of hearsay. Much of that evidence was hearsay evidence and not corroborated and not specific, and also with no time frame given. So I would argue that the evidence wasn't sufficient on those grounds. In addition, Your Honor, in GP, the court speaks to the requirement of a nexus and also matter of a minor, a nexus between impaired judgment from substances or the use of substances and the alleged harm. With respect to the evidence that there may have been individuals taking advantage of the respondent, there's no clear evidence that there's a specific nexus between that and substances. Moreover, the social worker who testified that those individuals were separate from the drug use. And finally, Your Honor, I'm not aware of any case law that would find that the criminal actions of third parties can be considered the type of physical harm under Section 35 that would qualify under prong 3. I think
even if she was susceptible to those actions based on her drug addiction.
I'm not aware of any authority for that proposition, Your Honor. In GP, the court, when it spoke in terms of the types of prong 3 harms, it was speaking in terms of a medical condition that was not being treated, that was putting a respondent in danger because of drug use, or if the respondent was going to be passed out in freezing cold weather and would be susceptible to extreme conditions, or if the respondent due to drug use wasn't receiving adequate nutrition. Again, there's no evidence of that nature here.
Well, there was a little bit. There was evidence of weight loss, correct?
Yes, Your Honor, but no evidence that weight loss placed the respondent in any physical harm. I also submit that with respect to evidence related to housing, that there was, I think, an inference that the appellate division was making that the respondent would be rendered homeless by a drug overdose that occurred with another resident in the apartment. That evidence of homelessness, or in this case, possible homelessness, that also doesn't suffice under prong 3 as evidence of very substantial physical impairment.
Can I go back to the in the matter of minor issue? At the beginning of this, you asked us to apply that case retroactively. Do we even need to go there, given that this is a pending appeal that we have not resolved after in the matter of minor was issued? Why don't we just apply it without considering the question of whether or not it would be truly retroactive?
Your Honor, the trial judge in this matter didn't have benefit of matter of a minor when this commitment was issued in 2018. So that's an argument in favor of retroactive application, or going through the analysis for retroactivity, applying matter of a minor that was issued within the last 2 months to a civil commitment that the trial was in 2018, but that is still a live controversy.
But isn't that equally true of in the matter of a minor itself, given that there were inadequate findings there, and obviously the trial judge there didn't have the benefit of the case?
Yes, Your Honor, and I understand your question. I think in matter of a minor, the case was resolved on the merits on insufficiency. The court had found sufficient evidence for the existence of a substance use disorder, but found that the evidence of likelihood of serious physical harm was inadequate and vacated on that basis.
Okay, I see your time has expired. Let me see whether or not Judge Desmond or Judge Milkey have any further questions. No. All right, thank you very much. We appreciate your argument. Stay safe, and we'll take the case under advisement and get an answer to you as soon as.
All right, we are live.
All right, good morning, Attorney Fisher. How are you today?
I'm well, Your Honor. Thank you. Good morning.
Good morning. Thank you for participating via Zoom. We know it's a challenge for both you as well as us. And so I want to say from the outset of the hearing that if we encounter any technological difficulties, we'll all do our best to overcome them. Next, and actually more importantly, on behalf of the panel, we hope that you're doing well, that you and your family members are healthy, and that you're weathering the pandemic as best as possible.
We're well. Thank you, Your Honor.
Good. Third, I'm going to introduce the panel. My name is Ariane Vuono. I'm joined by Justice James Milkey and Justice Kenneth Desmond. The other side is not appearing, as you know, and has not filed a brief, so it's just you. You still get your full 15 minutes to argue your case. The rules of appellate procedure that would have applied as if we were in a courtroom apply here. But we can kind of truncate that because, as I said, you're the only one here appearing before us. You can be assured that we know the record well. We've read it and it's been submitted to us, the transcript, the documents, etc. So please feel free to go ahead and start with your best argument, and you can start right now.
Thank you, Your Honor. Thank you. If it so pleases the court, I stand before the court as Attorney Chaz Fisher on behalf of Karen Blair. This is a matter of appeal from a probate matter coming out of Plymouth County Probate and Family Court. And this springs from a divorce of elderly individuals, older individuals.
Thank you for that clarification.
We're all, what's interesting about this case is that the individuals in their late 60s now, both of them had been previously married, and this being each of their fourth marriage. And at that point, you would have thought that both parties had gone through the process and understood the process, since they had been previously each divorced 3 times. For whatever reason, this divorce dragged on and dragged on. It was very extended. And I think possibly because both parties realized with their age and with their health conditions that this was the end of any sizable income in either of their estates. At the end of the divorce, the husband, Mr. Blair, had already taken a no work position because of a workers' compensation injury. Mrs. Blair actually suffered a heart attack during the course of the divorce proceedings. So she was at limited income and employment as well. And for that reason,
on that respect, the judge didn't actually enter a finding with respect to that, correct? I think the judge was looking for some documentation with respect to her that particular episode, and it appeared that he didn't receive it, which is why he penalized her, if I may say so, for with an attorney fee award.
Well, he received some documents. What the judges, out of due respect to Judge Stanton, what I understood his concern to be, Your Honor, was that he specifically requested Mrs. Blair and her doctors to provide documentation that she was on bed rest only. And for that reason, the first—
Just for that particular day, I guess, in terms of not being, I see. Mm-hmm.
Correct, because this trial was actually scheduled for December, approximately 4 or 5 months before the April 2018 trial. And we had gone in on an emergency continuance because Mrs. Blair had just had her heart.
And I didn't really want to distract you from your main arguments. I just wanted to be sure that I understood the record of that point carefully. Let's your main point is that there was an unequitable division of the assets, correct?
Correct, Your Honor. I feel that out of deference to Judge Stanton, that he did make an effort to go through each of the Section 34 factors. But in applying the facts and the evidence at trial, in his ultimate decision was an inequitable distribution. for three reasons, Your Honor. First, the assets that he did choose to give to Mrs. Blair were assets that the only way she would ever feel the value of those was to actually sell those assets. Namely, he gave her her home that both parties had testified during the course of the marriage was her home from the early 80s, well more than 15 years before the parties ever met, that she received from a prior divorce. And there's testimony that neither party, Mr. Blair, contributed to purchasing any aspect of that home. His name was never on the deed. And
there was some controversy, I guess, about the deed, but wasn't there testimony that was credited by the judge that there was at least two fairly significant remodeling projects at the house, the basement being redone, an addition being put on the house, 3 small parcels of land close by purchased in order to sort of cushion the house, if you will, and increase its value to a certain extent, even though I think it was very well established that each parcel itself independently did not have a huge value, and that he contributed to the mortgage while he was living there. Wasn't there evidence of that?
You're correct, Your Honor. He did recognize that there was additions that were made to the house and that there were improvements made to the house during the course of the marriage. And he also recognized that there was the 3 parcels of land which were purchased during the course of the marriage. And he recognized in his decision, meaning His Honor Judge Stanton, recognized in his decision that the parties did in fact go to an estate planning attorney during the course of the marriage prior to any suggestion of divorce, and that Mr. Blair did in fact sign over the parcels of land. What the judge did not find is whether Mr. Blair signed any portion of the trust. And that was a large hang-up starting this trial because the judge prevented any testimony from any witnesses other than the parties. We had specifically motioned and requested that the attorney who created the trust, who sat with the parties, be able to testify to explain what the intentions of the parties were at the time of the transfers. The judge prevented such testimony. Therefore, we were left with the memory of what transpired by lay persons who did not perfectly understand what a trust was or what its capacities were. However, both parties did admit, and it was recognized in the trial transcript and findings, is that both parties acknowledged that Mrs. Blair owned the property beforehand, that the intention was that that property ultimately go to her children, and thus the creation of a trust. Mr. Blair admitted that he knew that, and he was fine with the property being held for her children.
But the judge instead considered it to be a part of the marital estate, right? An asset, as well as the new home that was purchased by Mr. Blair.
Correct, Your Honor. What Judge Stanton did, and I hope it assisted the court in my appellate brief, I broke down line by line a total accounting of the judge's decision. And if you
saw that, and you come up with about $100,000 difference, I would say, give or take.
Correct, but I feel it's actually much more significant, Your Honor. On paper, it looks like it's approximately $100,000, but in application and in practicality, it's actually closer to $300,000. And I make that argument because the Judge Stanton put forth a equitable equity in Mrs. Blair's home, which he took out of the trust, and he assessed to her approximately $250,000. So of her $330,000 award, $250,000 is earmarked for the house, which, Your Honor, at my client's age and in her limited capacity for work as a result of her medical conditions, there is no bank that will actually refinance a property to allow her to take that money out. The only way she would then be able to seize on that asset would be to, in fact, sell it, which then she would have to find some other place to live or move in with family members. Whereas Mr. Blair was given the entirety of all liquid assets. He was given over $250,000 in the retirement package, his union pension, and his union annuity, all of which both parties had acknowledged were fully earned during the course of the marriage. That, in fact, was their savings for their retirement together, not anticipating divorce. In this case, the only thing that Mrs. Blair would have, besides the smaller assets, her vehicles and some bank accounts, would be the house that he took out of the trust. In order for her to actually move forward and maintain the same standard of living, would be to in fact sell that house. And there's case law, Your Honor, where the courts have recognized whether a division of assets is truly a division of assets if the assets that are earmarked for one party are locked up and therefore illiquid. And in this case, that would be our argument, is that Mrs. Blair, yes, she did receive her home, but it's an illiquid asset.
To what extent was that argument directly presented to the trial judge?
That was made during our closing arguments, I believe, Your Honor.
Were there closing arguments in this case? Because I thought that the case ended rather abruptly the second day of the trial.
There was, my recollection is that there was arguments, and then the judge said, do you want to reserve? And then we both said, we stated something shortly, but then we did reserve and we made our arguments on the papers.
They were submitted in writing. There was no oral argument. Okay.
What, if any, evidence was there with respect to her ability to refinance on the home or to get another mortgage on the house?
With all due respect, Your Honor, there was none. With respect to the other assets, in this case, the second portion is what were the conduct of the parties. And in this case, I feel that the judge did not take into full consideration the testimony and the facts that were produced as evidence. In one breath, the judge acknowledged that throughout the course of the marriage, Mr. Blair had regularly used drugs and that there was a long history of him having outside extramarital relationships. There was nothing of that nature against Mrs. Blair in either factor. In fact, the judge recognized that he does not attribute any negative behavior to Mrs. Blair. But yet, when you take into consideration the case law, which gives the judge discretion to therefore offset an inequitable treatment of the assets or division of assets based on a party's conduct, he did not actually follow through and apply what he found to be behavior unbecoming of the marriage against Mr. Blair. In fact, and this is the other major argument, Your Honor, is that throughout the course of the divorce, we argued that Mr. Blair repeatedly dissolved and divested of himself marital assets in contravention to Rule 411. There was—
Did you bring that issue before the court?
Excuse me?
Did you bring that issue before the court?
Yes, Your Honor. Yes, we brought it.
What came of it?
Nothing, Your Honor. We repeatedly brought it forward, and we brought it under our motions to compel because we had asked for documentation repeatedly, documenting the status of the workers' compensation award. The judge never allowed our motions to compel. And then when we did receive the information, it was after the money had already been distributed to Mr. Blair. And then that the judge did bring it up at various motion hearings where he had said, and I cited in my brief, that he would consider it at the time of the divorce to be 50-50 division. But yet when it came to the actual divorce judgment, he took no action against Mr. Blair, who readily acknowledged that he did receive the money and that he provided no money whatsoever to Mrs. Blair.
You're talking about the lump sum, excuse me, you're referring to the lump sum payment for the workman's comp, is that correct?
Correct. After his legal fees, it was approximately $92,000. And then after his legal fees, he testified that it was around $72,000.
But it was accounted for. In other words, the judge credited his testimony was accounted for. Part of it was used for a down payment, part of it was used to pay back loans from his sisters, etc.
Correct. Correct. He testified, and the judge credited his testimony that he used the entire amount of the money for his own use and that he had no money at the time of the divorce. And this is the other problem, is that throughout the judge's rationale, he credits Mr. Blair's statements that he paid back loans to his family members, But when Mrs. Blair testified as to loans that she received from her son with regard to purchasing the property, as well as for making renovations, he did not credit her.
Isn't he free
Now,
to do that?
what do you, are you suggesting that we do with that? Because of course, the judge here was the one, this is the quintessential situation where he's the one who can listen to the witnesses, see the witnesses, and made some pretty definitive credibility determinations here. And you're correct, of them when he made them, mostly he didn't credit your client. There were some things he didn't credit towards Mr. Blair as well, and particularly his drug use, his claim that he had not used drugs. We have to respect those, do we not?
We do. There is case law that says that the trier of fact is in the best position to make the determination of credibility of the witnesses. Yes, Your Honor.
So fair to say, however, you would have been satisfied with a 50-50 division, but your main point is, and I know I'm summarizing, is that you didn't actually receive 50-50, especially given the fact that the majority of what was given to your client was the marital home.
Correct, Your Honor. And secondarily of that is that as a practitioner, my big hang up with the judge's decision is the fact that he made various value decisions on various assets, all of which lacked any evidentiary evaluation from any expert whatsoever. And I made that argument at trial, and I said, Judge, and I see my time has run out.
You may finish.
But we made the argument at trial, Judge. In fact, the judge at the opening of the trial even noted that himself. How do I make a division of assets when you have no experts planned to testify to give me any valuations on any assets? He mentioned—
In particular, your client's business, I guess, is what he was talking about, right?
Not only the business, but also the real estate holdings, Your Honor.
That's right. The appraisals were somewhat stale, correct?
Right. And for that reason, because there was no experts permitted in to testify as to the appraisals, and there were no appraisals that were permitted, we had no valuation of the properties either. The only valuation that we had was when both counsel jointly valued the pension and the annuity.
Okay.
Of which those valuations were stipulated to, Your Honor.
Okay. I'm going to check to see if the panel has any additional questions. No, seeing that. Thank you very much. We appreciate your argument. We'll take the case.
All right, we are live.
Thank you, Megan. Good morning. Thank you so much for participating on your argument this morning via Zoom. It's a challenging time, and we're happy with the help of the clerk's office that we're able to move forward on these cases that are obviously so important to your clients. Before I go any further, on behalf of the panel, I would just like to say that I hope that you and your families are healthy and safe, and that you're weathering the pandemic in the best way that you possibly can. The panel I'll now introduce to you. I'm joined by Justice James Milkey, Justice Kenneth Desmond, and my name is Ariane Vuono. The rules of appellate procedure apply to this argument just like they would if we were in a regular courtroom, which means both sides have 15 minutes to present their argument, there is no rebuttal. With that said, I'll call the case officially Thomas versus Thomas, 2019-1090. And Attorney Johnson, you are the appellant, right?
No, Your Honor, I am the appellant.
I'm sorry. Attorney Summer, thank you.
Yes, thank you. Good morning, Your Honors. May it please the court, David Summer representing Miss Tricia Thomas. Tricia Thomas is the appellant in this case and the defendant in the court below. This case concerns the special motion to dismiss a memorandum of lis pendens. Ms. Thomas purchased a piece of real estate from her parents back in 2004, and that is the subject of this case. The premise of the appeal is that the court below used an incorrect legal standard when determining whether or not to grant the special motion to dismiss. specifically, and I know your honors have read all briefs and know the facts and what have you. This case was filed approximately 14 years after the deed from the appellee to the appellant was recorded at the Registry of Deeds. So under the statute of limitations, and the counts below were fraud and 93A, under the statute of limitations, at most, it would be 4 years. The only way that the appellee in this particular case could move forward is if equitable tolling applies, and that's really the that was the primary subject of the motion below, and that's the primary subject of our appeal in this particular case. And under the standards for equitable tolling, well, actually, let me step back. Under the special motion to dismiss, the standard of review is typically on the move on, and it's a summary judgment standard. And below, the appellant met that standard because there's no factual dispute as to whether or not the claim falls within the statute of limitations. The only thing that would possibly save the appellee in this particular case is equitable tolling. And
that is what saved the appellee in this case, right? Isn't that what Judge Ullman determined?
Right. Judge Ullman determined that equitable tolling applied. The issue is that Judge Ullman used an incorrect standard when determining whether or not equitable tolling was applicable.
And that's because why? Because he looked to the parents specifically rather than a reasonable person, or objectively?
That's correct. That's correct. And it's although Judge Ullman didn't make any written findings, it's evident from his statements in the hearing that's exactly what he was doing.
But what if he also said, I mean, one of the things that you argued is that this deed had been recorded, and so that a reasonable person would have known about it, right? That was one of the arguments that was made. And was it unreasonable for the judge to conclude, I don't really think so. I don't think that people normally hop down to the Registry of Deeds to check out their deed. That's not a reasonable thing to require of somebody.
Well, I think the deed is important because it sort of takes out of the equation this idea that it was inherently unknowable. And I think that's what Judge Ullman, he did talk to that. And in fact, I think it's on page 119 of the record, if I'm not mistaken.
But to know that it's knowable because it's recorded is a different inquiry. And I believe, speaking for myself, hypothetically an appropriate distinct inquiry as to whether or not that would have made the transfer of property known to a reasonable person. Because I think he said it's not really reasonable to expect, forget the person's age, an 18-year-old or an 88-year-old to be going down to the Registry of Deeds just to double check to make sure that everything's still okay.
Right, but keep in mind, that was not the end of the discussion as to whether or not the appellee should have known whether or not it was, whether or not the property was transferred. That, in my opinion, the deed itself, the recording of the deed, I think only sort of gets us to whether or not something is inherently unknowable. And then after that, then you have to sort of move to the next step. And in this particular case, the next step, which we attempted to bring to the judge's attention, is the tax returns, which I don't know how, and this was a two-family house where the the appellees had collected rents and
Okay, but counsel, can I just stop you there because you have some arguments against equitable tolling, but to prevail, you know, even if the parents bore the burden of proof on equitable tolling at trial, your client bore the burden of proof at this motion stage of showing there is no factual question here. What is out of bounds for the judge to say, we need a trial on these issues?
The tax records didn't come in either, did they?
well, right. I attempted to. They were mentioned in my in our submissions, and we didn't attach them because obviously they have. You know, when you submit somebody's tax returns to the court, I know there's a lot of procedures, but we did attempt. We had them there, and we did attempt to hand them to the judge, and the judge sort of stopped us and said, "Well, those tax returns may be some evidence, but they're not persuasive in this particular instance." But let me go back to Judge Milkey's point before about, I think the tax returns are absolutely persuasive because under the standards of a reasonable person, I don't know how you could suggest that a reasonable person who files tax returns saying that they own a house and collect rents for X number of years, and then all of a sudden file tax returns saying they don't own a house and don't collect rents, and one of the tax returns even has them paying rent, how a reasonable person wouldn't have any idea that the house had been transferred. And the part of the reason why I think this case has to be sent back is the judge really has to make and I know he said, and I really like Judge Ullman, actually. I had a trial in front of him recently. He's a great judge. But he cut me off and said, "I don't mean to cut you off." And the case really needs to be sent back for Judge Ullman to consider all the evidence in this particular case. And I think the tax returns are absolutely dispositive. And regardless of who has the burden at the motion stage, I don't know how the appellees could overcome the fact that they're filing these tax returns saying they own a house and then saying that they don't own a house. The reason why the judge discounted them is that he said that something to the effect of, well, they probably don't understand their tax returns either. But that's a non-issue. That is a non-issue.
Well, when we look at the standard, isn't the standard the reasonable person in the shoes of these parties?
You are absolutely correct. But that's
okay. So with that as our premise, wouldn't it be reasonable that a parent would be less likely to even think for a second that their daughter is trying to sell their home from underneath her, which would prompt them to go down to the registry of deeds?
Well, I would disagree with that. And there are cases, I mean, it wasn't a focus of the appeal because that wasn't an issue that had come up, but there are cases talking about parents or relatives with regard to fiduciary duties. Do relatives owe fiduciary duties to each other? And the appeal court in the SJC has answered absolutely not. There is no additional onus because somebody is a parent or what have you. And I think that's, but in any case, in this particular case, it wasn't even considered. It has to be sent back so the judge could make a more detailed finding as to whether these things are, whether the appellant has met her burden. And I think
so in other words, when the judge made comments and without making specific findings, to the extent that it found it unusual that there was 5 children here and that everything was being, the house, the main asset had been given or sold to one child, that he found that unusual. And in your view, it needs to be sent back, and so that testimony is taken, and that a finding of that nature is actually made on the basis of testimonial evidence rather than with the information that he had before him just during the hearing.
Well, I think I think he had information within the hearing, but I think he needs to consider all of these things, and I don't think he considered, in my view, the one piece of evidence which makes it absolutely unreasonable for them to believe that that they owned a house, parents or no parents. I mean, how could you suggest, and I agree with what Judge Desmond is saying, which is it's a reasonable person standard within the context that you're in. So in this case, it's parents and child. I agree with exactly what Judge Desmond is saying. However, in this particular case, the judge he didn't consider these things, and he didn't make his decision based on a reasonable person standard of a parent and a child. He made his decision, it would appear on the record, based upon the fact that the parents were not educated, didn't have an understanding of English. And I think
But wasn't it more than that? Wasn't it more than that? Wasn't it based on the emotional ties that the parents had with this particular daughter? That there was a desire for the parents to help her in a situation where she found herself in a spot down in Georgia. That coupled with their lack of education and sophisticated matters, along with the conduct at the lawyer's office herself. The daughter found the lawyer, that the daughter spoke separately to the lawyer aside from the parents, that the daughter did not provide the parents with any documentation following what you call a sale. Wasn't all that fair?
Well, the issue I have with what you're saying is that, and I'm not conceding any facts, and we're just for purposes of argument, if we were to concede that what happened, what the parents said happened, that there was, she defrauded her parents, she got them to sign over their house regarding this Georgia, to obtain money for her house in Georgia or what have you. The issue is that even if that was true, there's a statute of limitations for a reason. And the parents had a certain amount of time, and there has to be active fraud to sort of continue the equitable tolling. And in this case, there wasn't any suggestion of active fraud. The only thing was the parents paid for the bills or what have you. There was nothing in the record that said anything about Ms. Thomas engaging in active fraud. And the issue is that if you allow this case to stand, that it's going to create, in my opinion, a slippery slope where somebody who wants to suggest or wants to avoid a statute of limitations issue, they're going to say, well, I don't have the education and I don't understand English all that well.
I think the confidence there would be is that judges would be able to evaluate those cases and throw out the ones in which they were not substantiated, and let the others that he or she felt were go forward. But your time is up. Your points are well taken. Let me just determine whether or not either Justice Milkey or Justice Desmond have any further questions of you. Seeing none, no, thank you very much for your argument. And now we'll hear from, from Attorney Johnson, correct?
Correct. Thank you, Your Honors. May
Good morning.
it please the court, Danielle Johnson for the plaintiff's appellees. The Superior Court was correct to deny the defendant's special motion to dismiss because the plaintiff's claims are not frivolous. They are not devoid of reasonable facts. There is evidence of fraudulent concealment, and equitable tolling makes the statute of limitations defense invalid. Based on the limited record of pleadings and affidavits before this court today, the defendant did not meet her burden in showing that the plaintiffs do not have a claim in which they cannot be successful on.
The parents, to your brother's point, the parents had been filling out the tax documents prior to any loan against the equity in the house or sale of the house, depending on which way you look at it. Is that true?
Your Honor, the tax returns are not a part of this record. The defendants had an opportunity to put those records in. They did not. Also, there is an issue with the tax returns. The fact that the defendant has the plaintiff's tax returns is an issue.
Did you understand my question though? Did the parents fill out the tax returns on their own prior to any of this activity?
Not that we're aware of, Your Honor.
Okay.
And like I was mentioning, Your Honor, one of the defendant's friends was actually the person that prepared the plaintiff's taxes. So that in itself creates an issue and leads me back to the fraudulent concealment claim that the plaintiffs have. This case involves an elderly couple who were defrauded out of their family home of 24 years by their daughter. The record shows there were affirmative steps taken by the defendant to conceal the harm, given the plaintiff's limited educational facility in concert with their trusting relationship with their daughter. The plaintiffs had no reason to discover that harm. And also there's reasonable factual support and arguable basis in the law that the plaintiff's claims are not frivolous.
So what affirmative acts would you point to the daughter once she came back up to Massachusetts and was living in the house?
Sure, Your Honor. So after the fraudulent concealment in 2004, I think it's important to note that nothing changed. The daughter remained in Georgia. The parents remained in Massachusetts. Even after the daughter moved to Massachusetts, nothing changed. The parents continued to make upkeeps to the house. The parents continued to make repairs to the house. The daughter told the plaintiffs that she would take over the mortgage payments, when in actuality, the money that the parents were providing the defendant were to pay for her own mortgage, whereas the parents thought they were paying for their own mortgage. And that's detailed in both the plaintiff's affidavits, specifically pages 59 and 67 of the record appendix. And as I mentioned, even when they moved in, when the defendant moved in, nothing had changed. So all of those steps, I think, amount to affirmative steps taken by the defendant to conceal the fraud. In terms of whether or not the plaintiffs knew or should have had reason to know of the harm, I direct the court to the Riley v. Presnell case. In that case, the court held that the harm must be looked at the position from the plaintiff in these circumstances. Riley also goes on to say that when there is fraudulent concealment, as there is in this case, you have to look at the harm from the position of the plaintiff, not an outside observer. Here, there was evidence of fraudulent concealment. So in that case, the court has to look at the position of the plaintiffs from a standpoint of someone who's basically had the wool pulled over their eyes for a period of court.
How about the 2015 conversation in which the daughter is alleged to have told the parents, "I own the house"? Didn't that at least put them on notice?
To that point, Your Honor, I would argue that both the parents say that they had suspicions that the defendant had owned the house. I would direct the court to the case of Tracer Lab v. Industrial Nucleonics, where it specifically says mere suspicion does not amount to knowledge. And also, however, even if there is some sort of evidence that they may have known in 2015 that the defendant may have owned the house, they're still within the statute of limitations timeframe because they discovered this piece of mail in September of 2015. And this case was brought in, I believe, June of 2018. So that puts them within the 3-year statute of limitations frame. In terms of, back to my point of the reasonable person and whether the plaintiffs in this case should have known, I also want to direct the court to the SJC case of Doe v. Creighton, which specifically says when an educational and cultural background characteristics are pertinent and material to the claim, the court must take that into consideration. Here, Judge Ullman did that. The plaintiffs in this case are elderly immigrants. They have limited educational facility. They trusted their daughter. They relied on their daughter. They had a trusting relationship with their daughter to the point where they have a history of loaning her money and providing her with various loans. So when she requested that they give her another loan, that wasn't an issue for them. So that goes to, again, why the fraudulent concealment claim is successful here. And then if the court wants to take it a further step in determining what factors to be considered, the Finney v. Morgan case, another SJC case, provides different factors to consider when determining whether a plaintiff knew or should have known. There has to be some sort of trusting relationship, which is very evident in this case. There has to be a showing that the defendant controlled at least some of the facts to this case. That's evident here. There has to be a triggering event, which happened here in May of 2018. And then there also has to be an unawareness, on the plaintiff's part, which is again evident here.
The triggering event being the for sale sign?
Correct, Your Honor. In 2018, the for sale sign was the parent's triggering event in this case. The next point I want to bring up is with regards to the frivolous aspect. The court did not abuse its discretion in finding that this case is not frivolous. To succeed, the burden is on the defendant to prove that there are no facts in dispute, no reasonable legal analysis, or no valid statute of limitations defense. From the complaint and affidavit, the facts are in dispute. Clearly, the defendant is under the premise that she owns the home. We are contending that she does not. And there's a claim of fraudulent concealment, making prongs 2 and 3 viable defenses as well. And the lower court agreed with us, although he didn't provide a written opinion, his opinion, the record is replete with his findings that this is a frivolous case and that there is evidence that the defendant acted in a way that would have prevented her parents from knowing that they own the home. And I also want to touch base on the reason why we're here, which is the defendant is appealing the special motion to dismiss. The Ferguson v. Maxim case lays out that standard. The burden is on the defendant by a preponderance of the evidence to show that the plaintiff's claim is devoid of any reasonable factual support or arguable basis in the law. And to succeed on a motion to dismiss, there has to be a showing by the defendant there are no set of facts that the plaintiff can win on. I don't think that the defendant has met that burden, and therefore this is a case that is not frivolous. And again, the lower court judge had that same mindset and agreed with us on numerous occasions. Record appendix page 86, page 87, page 89 through 90. The judge specifically stated that this just was not a frivolous claim. A special motion to dismiss Liz Pendens is designed to weed out groundless litigation. That is not the case here. This court actually just made that decision in DeChico versus 180 Grant Street LLC. The plaintiffs have made a valid claim for fraudulent concealment. They have factual support that supports that in their pleadings and affidavits. The judge agreed with this. Therefore, there's a clear showing that there is fraudulent concealment. And I also want to touch on the point that my brother, or I believe, not my brother, but one of the justices brought up with regards to the recording of the deed. Mere recording of the deed does not put the plaintiffs on notice. And I direct the court to the SJC's case of Pruner versus Clerk of Superior Court, where the court found that comparable to a real estate purchase, which isn't the case here, there is no reason for a plaintiff to check the registry of deeds. And Justice Vuono, you make the point very well that there is no prompt here. There is no reason for the parents to, every now and again check the deed. And I think that goes back to the fraudulent concealment. They would have not had, or the plaintiffs in this situation did not have a reason to check the registry of deeds. Therefore, they didn't check the registry of deeds. And I think the affirmative steps that were taken by the defendant to cloak her facade of normalcy, I think, shows that the parents would have not had a reason to check the registry of deeds. I also want to touch base again on the reason that we're here, which is to appeal the judge's findings that the special motion to dismiss should not be granted. And the defendant has made claims, and we obviously are refuting those claims. And I think my brother also made note that this is akin to a motion for summary judgment. There are disputed facts that cannot be resolved at this stage. Therefore, as my brother mentioned, this has to be kicked back to the lower court. In the Ferguson v. Maxim case, it was clearly stated that discovery is stayed when there's a filing of a special motion to dismiss. This case is in its infancy. We have not done lengthy discovery. We don't have a complete record here. So to find that there are not facts in dispute would be inappropriate for this court. I think that is all of the points that I have. And lastly, I can't stress enough that the taxes just aren't in this record. We don't have a copy of the taxes. We don't know what those look like. So I think that's not anything that this court can consider because it's not before the record. If there aren't any other questions, I will leave the remainder of my points to the brief.
Okay, I'll check. No questions from Judge Milkey. No, thank you very much. Thank you both very much for very helpful arguments. And we'll take the case under advisement and get back to you as soon as we can, okay? Meanwhile, be well and stay healthy, okay?
Thank you.
Thank you both.